Philosophy 212, Ethics in Business and Society. This lesson's topic is sex work. We will look at the definition of the term, history and law surrounding it, specifically in relation to pornography and prostitution. What is sex work? Sex work can be defined as the providing of sexual services for money or goods. A sex worker is a person who engages in sex work. Examples include stripping, also known as exotic dancing, pornography, specifically as actors in pornography, and prostitution. Related fields to sex work, which may also, by extension, be considered to be sex work, are strip club management and other employees at such establishments, pornography production, pornography web hosting and distribution, and prostitution management, whether as a so-called pimp or the madam of a brothel. We turn now to the form of sex work known as pornography. Pornography can be defined as the depiction of erotic behavior, as in pictures or writing, intended to cause sexual excitement. Note that it is the intention of the manufacturer that makes something pornography. They intend it to cause sexual excitement. There are other things that may cause sexual excitement, but that is not their primary intention. For example, an advertisement for underwear may cause sexual excitement in the viewer, but the intention is to sell underwear, not to cause sexual excitement, although that may be part of the advertising campaign. As one knows, people often use sex to sell things. But if it is not the direct intention of the product to cause sexual behavior, it is not pornography, even though to some it may be pornographic. It is often said that pornography is in the eye of the beholder. Some people might consider something pornographic that others consider erotica. And what some may consider erotica or pornography, others may consider obscene. Only one of these, obscenity, has been given a strict legal definition. Another distinction to make is between hardcore and softcore pornography. Hardcore pornography typically involves actual sex acts, whereas softcore can be anything from simulated sexual acts to people fully clothed in a sexual situation, or even alone in a provocative way. Now some history of pornography. Over 5,000 years ago, there was a statue created of a man and woman having sexual intercourse. However, we do not know whether this was pornographic or pornography because we do not know the intention of the creator. It could just as well have been a fertility idol used to appease the gods for growth of crops and having of children. Around 800 to 600 years before the birth of Christ, ancient Greek and Roman erotica was quite common in households and in the public square. This was not discovered by modern peoples till much later and was quite controversial. For over 500 years, the Roman Catholic Church kept an index of forbidden books. Typically, books on this list were those that were considered heretical or blasphemous, but there were also works that would be considered pornography on the list. It was forbidden for Catholics to read or possess these books. In 1748, the first pornographic novel in English was published, Fanny Hill, or Memoirs of a Woman of Pleasure. It is now readily available on the internet since it has moved into the public domain a long time ago. In the 1870s, the U.S. Congress passed the Comstock laws. These were laws that made it illegal to send obscene material through the U.S. mails. This would include not only materials we would nowadays consider pornographic, but also literature on birth control and family planning. In 1908, the earliest known hardcore pornographic film was published, a French film, with the title you see here. We see now pornography following technology. In the 1950s, Playboy magazine began and became the most popular pornographic magazine of its time. In 1957, the case of Roth versus United States legally defined obscenity. In the late 60s, in the case of Stanley versus Georgia, private possession of obscene matter was ruled legal. In the early 70s, a porno chic fad began to take off, where regular, middle-class working folk would go to the theater to see pornographic films, often as couples. The landmark case of Miller versus California clarified obscenity with the Miller test. This now gave juries, judges, and lawyers guidelines to determine whether something was obscene. If it were declared obscene, it could be legally banned under the law, and there are specific categories that things would have to fall under to be labeled obscene. Most mainstream pornography, whether softcore or hardcore, would not fail the Miller test, and thus is legal and protected by the First Amendment of the United States Constitution. Pornography markets grew when VHS tape was introduced in the 1970s. In the late 80s, in the case of California versus Freeman, the California Supreme Court made a distinction between pornography and prostitution, effectively legalizing the pornography industry in the state of California. Porn entrepreneur Reuben Sturman was sentenced in 1989 to 10 years in prison for tax evasion. By then, pornography had begun to become mainstream, and fewer people would be prosecuted as pornographers. In the 90s, DVDs were introduced, and the internet was fully commercialized. This led to a huge boom in the pornography industry. It was easy to get, it was much more private to access it, and it became much more widespread. By the early 2000s, 4% of the most popular websites were pornography related. 13% of web searches are for pornographic content in 2010. According to Forbes, the global pornography industry takes in $97 billion a year. The U.S. makes up about $10 to $12 billion of that market. But the revenue from traditional pornography has been shrinking due to piracy and free content. In a way, amateurs are taking over. The First Amendment to the United States Constitution protects many important rights, including freedom of religion, freedom of speech and of the press, the right of the people to assemble and petition the government. Most important to discussions of pornography is known as the Speech Clause, which says Congress shall make no law abridging the freedom of speech. The framers of the Constitution understood speech to mean political speech, where one is criticizing the government or the government's policies. However, the courts have interpreted the term speech to include all forms of expression, whether strictly verbal or not. The Constitution protects pornography as speech, as long as such speech is not declared obscene. We now turn to the variety of sex work known as prostitution. It has been called the world's oldest profession. One might make a joke here about cavemen and cave women, but that joke might be in bad taste. Prostitution can be defined as the practice or occupation of engaging in sexual activity with someone for payment. Possible services include sexual intercourse, other sex acts, for example, oral sex, fetish, such as bondage and domination, and the girlfriend experience. Modes of distribution include street walking, escort or outcall service, and brothel or a house of prostitution. Prehistory, we know nothing. 2,000 years before Christ, we know there was prostitution in the ancient world from the Bible and other sources. Sumerian records list prostitute as a profession. Hammurabi's code, the earliest code of law we know of, details rights of prostitutes. In the Bible, sex work for Israelite women was banned under Moses' law. Men using sex service was tolerated, as long as this was not with Israelite women, of course. Brothels were legal in China and Greece 600 years before Christ. Prostitution was forbidden by the Catholic Church in its early days, but tolerated. St. Augustine said, "If you expel prostitution from society, you will unsettle everything on account of lusts." The Visigoths criminalized prostitution in the 500s. The Holy Roman Army began punishing it in the Middle Ages. England regulated prostitution. In 1254, France abolished prostitution. England ended regulation in 1546 and then outlawed prostitution. In the 16th and 17th centuries, attitudes toward prostitution became more strict. Street walking was banned in colonial Massachusetts. But prostitutes followed Civil War armies around in the 1860s. This was also a time when we saw the proliferation of early pornography. In the late 19th century, there were over 200 houses of prostitution in Lower Manhattan in New York City. Saloons, gambling dens, and brothels flourished in our own downtown Sioux City. In 1910, the Mann Act was enacted, which regulated so-called white slavery, which made it illegal to transport someone across state lines for sexual activity. The Supreme Court decision Hope v. United States left regulating prostitution to the states. In 1959, Britain legalized prostitution. In 1971, licensed brothels were allowed to operate in Nevada in any county with a population of less than 700,000. This would not include Clark County, where Las Vegas is located, or the county where Reno, Nevada is located. However, many small counties have licensed brothels. In 2009, male prostitutes were legalized in Nevada brothels. This map shows prostitution laws worldwide. Green, they are legal and regulated, etc. The money spent on prostitution worldwide is estimated to be around $186 billion a year. The following countries spend approximately these amounts. The United States is fourth on the list, spending around $14.6 billion on prostitution, even though it is mostly illegal. So-called escort services operate legally in every state in the United States. There are certain legal facts that make this possible and make it particularly difficult to prosecute people for prostitution. It is not illegal in the United States for adults to engage in consensual sexual activities. It is not illegal to pay someone for their non-sexual company. Thus, you could pay someone to go on a date with you, and then at some point during that date, they could agree to have sex with you. You could pay them for the date, and perhaps even tip them for it having been an exceptionally good date. All of that is, strictly speaking, legal activity. One would have to prove that prostitution took place in order to prosecute someone. In the state of Iowa, prostitution, soliciting prostitution, pimping, and pandering, which would be, for example, keeping a home for the purposes of prostitution, are aggravated misdemeanors in Iowa. If one is convicted of pimping or pandering, one must register as a sex offender. Prostitutes or their customers do not have to do so. The primary way that people are caught is because law enforcement initiates what's known as a sting operation, where they'll set up a website, for example, advertising prostitution services. Someone will contact someone thinking they're a prostitute or a pimp. This person will actually be in law enforcement. The person will show up for their meeting with the sex worker and then be arrested for soliciting prostitution. We've looked at history and legal issues surrounding sex work, particularly prostitution and pornography. In the coming lesson, we'll have discussion surrounding these issues.